Okay, so good day everyone. So I'm going to discuss about labor and management relations or the collective bargaining. So in this topic, we have objectives such as to understand the rights of the workers and the employees, to discuss the government agencies and their functions to ensure that both rights of the employers and employees would be protected, to understand the process on how to bargain collectively in cooperations with the management, to observe legal procedures in presenting a case, to know the government regulations on employment and their different functions, and to be aware of the basic duties of the workers and employers. So we have two things to consider. The first one is the labor, which we refer to the hired workers of an industry. And the capital is those we refer the owner or investors of an industry. So the Labor Code of the Philippines defines the relationship between capital and labor, but no amount of law can truly harmonize men unless man himself accepts that goodness and justice comes from within. Okay, so the questions of just wage. So this question is often the bone of contention between labor and capital. So it is usually claimed that wages are fixed by mutual agreement between employee and employer. Thus, it is suggested that the employer does the rightly when he fulfills his obligations to the workers by paying him what has been agreed upon. So let's move to minimum wage. So in minimum wage, it is the rate of pay fixed either by a collective bargaining agreement or by government enactment as the lowest wage payable to specified categories of employees. So here is the minimum wage range of our country. So the highest minimum wage range is in the NCR, 500 to 537, while the lowest minimum wage range is in Bangsamoro region. They have 290 to 325 pesos. So in general, the setting of a minimum wage does not preclude the right of employees to demand wages above the establishment minimum. The method of establishing a minimum wage by collective bargaining suffers from a serious limitation. However, because the collective bargaining agreements cover only the workers in the specific plant, crafts, industry, or local area, and hence are inadequate in situations in which wage rates prevailing throughout an entire nation have fallen to excessively low levels. So the realization of this shortcoming has led labor unions to demand government minimum wage programs as early as 1890s and resulted in the enactment of the legislations setting minimum wages. So we have here some government regulations or four government regulators. First one is the Department of Labor and Employment, the National Labor Relations Commission, the Regional Tripartite Wages and Productivity, and also the National Wages and Productivity Commissions. So first is the DOLE, the Department of Labor and Employment. They are the one who are responsible for the overall regulations of employment in the Philippines. They have three areas of authority such as promotions of employment and apprenticeship, then the workers' protections and welfare, and also the promotions and maintenance of the industrial peace. Okay, so next is the National Labor Relations Commission, NLRC. This agency coordinates programs and policies with DOLE, but it is otherwise a separate agency. The NLCR oversees unfair labor practices allegations, job terminations, disputes, and other labor matters not strictly related to wages. It consists of 14 commissioners in combination with the National Conciliation and Mediation Board, the NCMB. The NLRC serves as the quasi-judicial mechanism for hearing and adjudicating worker claims, and it has exclusive appellate jurisdictions over all cases decided by the labor arbiters. So, mo ni sila ang malimo ila or mo-accredit sa union or association sa employees. So, in other way, una ni sila nga mo husay if ever na ay problema from the union or from the workers to the capital, from the laborers to the capital. So, next would be the RTWPC, the Regional Tripartite Wages and Productivity Commissions. So, there are 15 regional boards, each representing a sections of the country. The boards assist the NPWC, which is the first one, which is we will tackle next. And then especially they are charged with developing plans, programs, and projects related to wages, income, and productivity improvements for their respective regions, as well as determining and fixing minimum wages rate. They also act on applications for exemptions from prescribed wage rates. So, this group or this agency, bali sila ang mo determine sa wages sa isa ka lugar, or so bali sila ang mo plan, sila ang mo pasaka o proposal if ever unsa na ang possible, or if ever gusto ba sila nga mo possible ba mo taas ni nga kuan, mo taas ba ni siya nga minimum wage or something like that. So they consist of LGUs and businessmen, also the union or the employees. So next one is the National Wages and Productivity Commissions, and NWPC. So the NWPC consults and advises the national government on wages and worker productivity. It formulates policies and guidelines on the issues, prescribes rules and guidelines for determining minimum wage and productivity standards, and reviews wage levels set by the RTWPC for compliance with prescribed guidelines and national development plans. It also studies and disseminates information on wages and productivity and other related informations on employment, cost of living, and labor costs. So sila ang mo approve or muhimo o policies and guidelines nga giset or gipropose sa RTWPC. So, the minimum wage prescribed by the law may not necessarily be a just wage. So, what is really a just wage? So, it defines the remuneration which is enough to support the wage earner in reasonable and frugal comfort. So, it's like a family wage that will enable man to provide a sufficiency or decent food and clothing for himself and his family, a decent home, security for sickness and old age, and means of leisure for moderate and wholesome recreation. And now, let's tackle about the unionism and the natural right. So, every worker has right to join a union in order to protest his livelihood and to cooperate in building social order. The Catholic Bishops of the Philippines notes that it is morally wrong and in our country a crime punishable by law for anyone to interfere with this natural right, either by threat or by discriminations against those who join such association. Because labor, if organized, can have an effective voice to protect its rights and to bargain collectively with capital. Therefore, for as long as unions are peaceful and seek their objectives by lawful means, they are beneficial to its members and to the society as a whole. So, there is a morality of strike. So, organized labor often resort to strike. A strike is a cessation from work by workers for the purpose of forcing employers to assert to their demand. Henry Davis, 1984. So, in order to have a peaceful strike, So for a strike to be immoral, the following conditions must be present. First is if there is a sufficient and just reason for it. And then the intended good result must be proportionate to the evil effects. Also that the means employed are lawful, which a strike should not be resorted to unless all other means of conciliation have been tried. There must be a sufficient reason for holding it. And then also the good result must be weighed as against the evil effects. Prudence dictated that where more harm than good would result, a strike should be rolled out. And then threats, coercions, or violence should never be employed by either labor or capital in settling differences. So we have here the rights of labor. So what are the rights? First is the Philippines is a signatory of the United Nations International Covenant on Economic, Social, and Cultural Rights. We cite those pertaining to labor. The state parties to the present covenant recognize the right to work, which includes the right of everyone to the opportunity to gain his living by work which he freely chooses or accepts, and wills to appropriate steps to safeguard this right from Part 3 of Article 6. Include here is the state parties to the present covenant recognize the right of everyone to the enjoyment of just and favorable conditions of work which ensured in particular such as remuneration which provide all workers as a minimum, fair wages and equal remunerations for work without distinctions of any kind. Also, a decent living for themselves and their families in accordance with the provisions of the present covenant. We have here also safe and healthy working conditions, equal opportunities for everyone to be promoted to an appropriate higher level subject to no considerations other than seniority and competence, and also rest, leisure, reasonable limitations of working hours and periodic holidays with pay as well as remunerations for public holidays from Article 7. And also, another rights is the state parties to the present covenant undertake to ensure that the right of everyone to form trade unions and join the trade union of his choice subject only to the right of the organizations concerned for the promotions and protections of his economic and social interests. No restriction may be placed on the exercise of his right other than those prescribed by law and which are necessary in a democratic society in the interest of national security or public order for the protections of the rights and freedom of others. And also, the right of trade unions to establish national federations or confederations and the right of the latter to form or join international trade union organizations. Here also, the right of trade unions to function freely subject to no limitations other than those prescribed by the law and which are necessary in a democratic society in the interest of national security or public order or for the protections of the right and freedom of the others. And also the right to strike, provided that it is exercised in conformity with the law of the particular country from Article 8. We have these basic duties as workers. So conscience dictates the duties of a worker. It is conscience because it is impossible for anyone not to have an inkling of these duties, namely, work honestly and comply with all the requirements. As a worker, never injure capital nor steal from the employer. Never outrage the person of the employer, never employ deceit nor violence in presenting a cost, and never consort with the agitators or men of evil principles. So, aside from that, we also have basic duties of the employers. So, employers have the sacred task of caring for their workers. There is the golden opportunity to become the ethical man for others. They must be fair-minded and generous in their dispositions. So, here are some duties of employers towards their worker. First is respect the human dignity of the workers. We should appreciate their work. We should never treat them as slaves for making money, and never assign them tasks beyond their strength. Do not employ them in the work not suited to their sex. And then give them commensurate wages. Provide for their health and social recreations. Provide them time to practice their religion. Instruct them on how to use their money wisely. Instruct them to love their family and provide them with opportunities. So, aside from that, here are also some unfair labor practices of employers. So, it shall be unlawful for an employer to commit any of the following unfair labor practices written in the Article 248. So, it is to interfere with, restrain, or coerce employees in the exercise of their right to self-organization. To require as a condition for employment that a person or an employee shall not join a labor organization or shall withdraw from one to which he belongs. To contract out services or functions being performed by union members when such will interfere with, restrain, or coerce employees in the exercise of their rights to self-organization. To initiate, dominate, assist, or otherwise interfere with the formations or administration of any labor organizations, including the giving of financial or other support to it or its organizers or supporters. Another one is to discriminate the regards to wages, hours, in regards to wages and hours of work and other terms and conditions of employment in order to encourage or discourage membership in any labor organization. So, magdili siya pwede blackmail, something ana. And the next is to dismiss, discharge, or otherwise prejudice or discriminate against an employee for having given or being about to give testimony under this code. Also, to violate the duty to bargain collectively as prescribed by this code. To pay negotiations or attorneys' fees to the union or its officers or agents as part of the settlement of any issue in collective bargaining or any other disputes, or also to violate a collective bargaining agreement. So, those things are big no-no to the employers to do towards their workers. And let's move to labor relation policy. So here are some policy. In Article 211, Declaration of Policy, it is the policy of the state to first, promote and emphasize the primary of free collective bargaining and negotiation, including voluntary mediation and conciliation as modes of settling labor and industrial dispute. Promote free trade unionism as an instrument for the enhancement of democracy and justice and development. Also foster the free and voluntary organizations of a strong and united labor movement. Another one is promote the enlightenment of workers concerning their rights and obligations as union members and as employees. Also provide an adequate administrative machinery for the expeditious settlement of a labor dispute. Another one, ensure a stable but dynamic and just industrial peace, and also ensure that participations of workers in decisions and policy-making processes affecting their rights, duties, and welfare. So, another right also is to encourage a truly, another policy also is to encourage a truly democratic method in regulating the relations between the employers and the employees by means of agreements freely entered into thorough collective bargaining. No court, administrative agencies, or officials shall have the power to set or fix wages, rates of pay, hours of work, or other terms and conditions of employment except as otherwise provided under this code, which as amended by RA 6715. So here are those included. First is the labor relations law, parties to labor relation cases, collective bargaining, arbitrations, mediation, labor relation policy prior to the labor code. Also, under of this is the regime of compulsory arbitration shift to collective bargaining. Then labor relations policy under the 1987 Constitution. So, let's talk about labor relation law. It's about the concern with stabilizations of relation of employer and employees and seek for forestall and adjust differences between them by the encouragement of the collective bargaining and settlement of labor dispute through conciliation, mediation, and arbitration. So, naadira naka-under ang unsaon nila pagsabot. Okay? From labor and the capital. So, another one is the parties to labor relations cases. So, every labor relations cases involve three parties. The employees organization, the company, the management, the union, the employees organization, which is the union, association, the company, and the public, and even have certain rights. The Civil Code of the Philippines expressly provides that neither capital nor labor shall act oppressively against each other or impair the interest or convenience of the public. So, what is collective bargaining? So, it has been defined as the process of negotiation between employer or employees and employees organization or union to reach agreement on the terms and conditions of employment for a specified period. It covers the entire range of organized relationship between the employers and employees represented by union. This includes the negotiation, interpretations, or applications of the labor contract. So, in collective bargaining also, so it is a dynamic and continuous process actually. So it does not end with the executions of a collective bargaining agreement. The effectiveness of the process to maintain industrial peace and stability depends upon the good faith of the parties. So both. Workers cannot, of course, bargain collectively for terms and conditions of the employment whether at the plant, enterprise, industry, or national level unless they are organized into trade or union. So, dili siya pwede og individual ang mag-strike. And then, collective bargaining has an important standard or setting functions together with the law. It constitutes the main source of regulations governing wage, hours of work, and other terms and conditions of employment. It likewise renders the decision-making process more democratic since decisions are reached by agreement between all parties concerning rather than unilaterally by the employment or the government. Collective bargaining has in many cases also been found to be an effective means of solving disputes between employers and the workers, thereby representing an element of stability and order in industrial relationship. So, okay, let's proceed. So, what is arbitration? Okay, in arbitration, it is the determinations submissions of dispute matter to provide official person selected in the manner provided by law or agreement. Here is also compulsory arbitrations, that which occurs when the consent of one party is enforced by statutory provisions. Also, voluntary submission is an agreement by which parties agree to submit their differences to the decisions of a referee or arbitrator. It is sometimes termed as reference. In a wide sense, arbitration may embrace the whole method of settling controversies and include all the various steps needed to resolve the problems. But in more strict use, the term denotes only the submissions and hearing, the decision being separated, spoken of, and called an award. An award is a judgment or decision of arbitrators or referees on a matter submitted to them. It is also the writing containing such judgment. Mediation. The act of a third person who interferes between two contending parties with a view to reconcile them or persuade them to adjust or settle their disputes is called mediation. Also, labor relations policy prior to the Labor Code. First is the regime of compulsory arbitration. In Article 14, Section 6 of the Constitution of the Philippines promulgated in 1953 provides that the state shall afford protections to labor, especially to working women and minors, and regulate the relations between labor and capital in industry and agriculture. The state may provide for compulsory arbitration. Next one is the shift to collective bargaining. The Court of Industrial Relations, as the main machinery to enforce the system of compulsory arbitration, however, failed in the long run to give adequate protections to labor and accord social justice. So another policy is the labor relations policy under the 1987 Constitution. It stated that Section 3 of Article 3 of the 1987 Constitution guarantees to all workers the right, among others, to self-organization, collective bargaining, and negotiation, peaceful and concerted activities, including the right to strike in the accordance with the law and to participate in policy and decision-making processes affecting the rights and benefits as may be provided by law. The state also mandates under this profession to provide the principle of shared responsibility between the workers and employers and preferential use of voluntary modes of settling disputes, including conciliation. So those are the labor relations policy. So let's move to the collective bargaining and administration of agreements. Procedure in collective bargaining agreement in Article 250. So the following are procedures in collective bargaining. First is when a party desires to negotiate an agreement, it shall serve a written notice upon the other party with a statement of its proposal. The other party shall reply thereto not late than 10 calendar days from receipt of such notice. Next step is, should differences arise on the basis of such notice and reply, either party may request for a conference which shall begin to no later than 10 calendar days from the date of request. So, next is if disputes are not settled, the board shall intervene upon request of either or both parties or at its own initiative and immediately call the parties to conciliation meetings. The board shall have the power to issue subpoenas. Issue subpoenas requiring the attendance of the parties to such meetings. The board may call. Then, during conciliation proceedings with the board, the parties are prohibited from doing any act which may disrupt or impede the early settlement of the dispute. And the board shall exert their case to a voluntary arbitrator, as amended by RA 6715. So, here is Article 251 stated that duty to bargain collectively in the absence of collective bargaining agreements. In the absence of collective bargaining agreement or other voluntary agreement, providing for a more expeditious manner of collective bargaining, it shall be the duty of the employer and the representatives of the employees to bargain collectively in accordance with the provisions of this code. And also we have Article 251 stated that meaning of duty to bargain collectively means the performance of a mutual obligations to meet and confirm promptly and expeditiously in good faith for the purpose of negotiating an agreement with respect to wages, hours of work, and all other terms and conditions of employment, including proposals for adjusting any grievances or questions arising under such agreement and executing a contract incorporating such agreement if requested by either party. But such duty does not compel any party to agree to a proposal or to make any concessions. Under this article is duty requires reasonable efforts to reach agreement. So, it is true collective bargaining involves more than the holding of conferences and the exchange of pleasantries. While the law does not compel the parties to reach an agreement, they must approach the negotiation with an open mind and make reasonable grounds of agreements. Proposals must be matched with counter proposals. So, pwede makapropose ang union and then mag-counter proposal pod ang company. Another one is sphere of collective bargaining. So, under the foregoing article, the obligations of the parties to bargain collectively covers wages, hours of work, and all other terms and conditions of employment, including proposals for adjusting any of the aforesaid subject constitute unfair labor practiced. Conversely, a party's insistence to negotiate on matters having reasonable relation to the above-mentioned subject would also constitute an unfair labor practice. Third one, So, the third one is usual provision stipulations and clauses in collective bargaining agreement. State that the duty to bargain collectively includes, according to the foregoing article, the duty to execute a contract incorporating their agreement. If this is requested by either party, this contract is called collective bargaining agreement, CBA. The provisions, stipulation, and clauses usually found in the CBA are the following. Okay, so first is the definitions of bargaining unit. This is a statement of the scope of the appropriate bargaining unit covered by the agreement and of the positions included and excluded from the unit. So next is the union security clause. This is intended to maintain the strength of the contracting union during the life of the agreement and safeguard it against the perfidy or fickleness of its own members and incursions by the employer. And the other one is check-off provisions. Pursuant to these provisions, the employer undertakes to deduct from the wages of union members, union dues, and the assessment and remit the same to the treasurer of the union. So another one is management prerogative clause. The rights and prerogative of the company are enumerated in these provisions. And then economic benefits. Provisions granting economic benefits to the employers such as increases, vacations, and sick leaves, and hospitalization and retirement. So other is provisions on administrations of agreement. So in Article 260 of the Labor Code requires the parties to include in their agreement provisions to ensure mutual observance of the terms and conditions of the agreement and the established machinery for the adjustment of grievances. Another one is the voluntary arbitration clause. The parties are also required to provide in their agreement for the submissions to voluntary arbitrations of grievance procedure and to designate in advance an arbitrator or panel of arbitrators or provide the manner for the selections of such arbitrator or panel of arbitrators in Article 260 Labor Code. So, also no strike, no lockout clause. The parties may stipulate that during the life of the agreement, the union shall not go on strike and the employer shall not declare a lockout. Also, completeness of the agreement. In this clause, the parties stipulate that during the life of the agreement, the union shall not go on strike and the employer shall not declare a lockout. Another one is provisions of family planning, participations in sports, etc. So the parties undertake to encourage employee participations in programs for family planning or population control and in sports and recreational activities to reduce monotony and to have periodic discussions on cooperative schemes to increase productivity and sharing of profits therefrom. Last one is durations of agreement. So this provision states the durations of the agreement. So another thing includes in collective bargaining and administration of agreement is the binding effect of CBA interpretation. So, a collective bargaining agreement entered into by officers of union as agents of the members and an employer gives rise to valid and foreseeable contractual relations against the individual union member in the matters that affect them peculiarly and against the union in matters that affect the entire membership or large classes of its members. So, it's stated also here that a bargaining contract entered into by the duly certified bargaining agent is binding on all employees within the bargaining unit since under Article 242B, a legitimate labor union, when certified, acts as the exclusive representative of all employees within the units for purposes of collective bargaining. Beside, under Article 231, the CBA, when submitted to the Bureau of Local Relations, must be accompanied by a verified proof of ratifications by the majority of all the workers in the bargaining unit. A collective bargaining agreement, also just like any other contract, is respected as the law between the contracting parties and the compliance therewith in a good faith is mandated. Similarly, the rules embodied in the civil code on the proper interpretations of contracts can very well govern. The intentions of the parties is primordial if the terms of the contract are clear. The literal meaning of the stipulations shall control, but if the words appear to be contrary to the evident intentions of the parties, the latter shall prevail over the former. Also, it stated that there is nothing sinister in a stipulation in the CBA to the effect that increases provided therein shall be creditable to the wage increases that are or may be mandated within the applicable period by law. Such stipulation merely creates equivalence between legal and contractual imperatives, rendering both obligations susceptible of performance by compliance with others subject only to the conditions that were the increases given under the agreement fall short of those fixed by law. The difference must be made up by the employer. Okay. And it stated also that where the collective bargaining agreement provides that should there be any government-mandated wage increases and or allowances, the same shall be over and above the benefits herein granted. It is a grave abuse of discretion for the voluntary arbitrators to require the employer to grant increase to all employees covered by the government regardless of whether or not they are entitled to the wage increases provided for in the wage orders. So, the last is effect of shifts of union allegiance of employees after executions of the CBA. Substitutionary doctrine. So, stated here that the shift of employees union allegiance after the executions of collective bargaining agreement will not result in the cancellations of the contract. Otherwise, employees can easily cancel a CBA by the simple expedients of leaving the bargaining agent. While the employees no doubt can change their agent, the contract continues to bind them up to its expiration date. Otherwise, employees can easily revoke or renege to the prejudice of the employer an existing contract by the simple expedient of changing their union. More importantly, we should not overlook the fact that the employees, not the union, are true parties interested in the contract. The new agent may, however, bargain for the shortening of the period of the contract. So, let's move on the last article, the Article 253. It stated that duty to bargain collectively when there is collective bargaining agreement, when there is a collective bargaining agreement, the duty to bargain collectively shall also mean that neither party shall terminate nor modify such agreement during its lifetime. However, either party can serve a written notice to terminate or modify the agreement at least 60 days prior to its expiration date. It shall be the duty of both parties to keep the status quo and to continue in full force and effect the terms and conditions of existing agreement during the 60-day period and or until a new agreement is reached by the party. So those are the policies and agreements regarding on the collective bargaining. Thank you.